Another thing that you can do is compare the individual to others out in the field and show how this person is different, how their knowledge is different from others in the same occupation, and compare to other employees within the company as well. So you've got to be creative. You've got to look for ways to distinguish the employees one against another. It could be the different kinds of projects that that person was assigned to. It could be the trainings that were available to that person. It could be various other things. But those are the kinds of documents that you should look for and the supporting information that you want to provide. Okay, so again, training materials, awards that the person may have received, a long employment history with the employer and highlighting how that particular employee may have been instrumental in developing a product or a tool or technology that is now the subject of this specialized knowledge petition. Okay. You can show that this person supervises other employees and is a more responsible person within the organization, has a higher salary than others. You can provide expert opinion letters from people outside the organization, neutral third parties, professors and others who are willing to explain why this particular job is requiring specialized knowledge. You might show press releases or articles about the technology. You might have patents or trademarks. Those are very helpful because, of course, if it's patented, it means it's proprietary, it means it's special. And if the employee has special knowledge about those things, then that's a very good position to be in. In the third-party placements, it's important to show that the petitioner is maintaining control of the L1B employee. Just like we talked about under H1B cases, in an L1B context, you cannot send the employee to a client location and simply leave the responsibility of that person to the client, right? You've got to show that as your organization is sending that person, you will be responsible for the worker. You will have supervision over the worker and make sure their performance is meeting the standards of your company, of the client, and so on, but that you're involved. And in most cases, you should actually have a manager over the employee at the location where you have sent that person, a supervisor on site. Okay, if you don't have it, probably immigration is not going to be very happy. It's also important that when you're showing when you're sending someone to a third-party location, that specialized knowledge will relate back to your own technology, your own products and services or methodologies and so on. Those will be the things the person will bring to the third party, not only knowing or having knowledge of the end client's technologies and services. Are you having questions? If you are, hopefully we can answer them in a little bit. Okay, another trend that we see under the L1 blanket program are issues surrounding the stamping of the I-129S. Maybe you've seen it. It may not happen so much in India, but it happens in other places around the globe where the individual will bring the L blanket petition to the consulate. The consulate will not have read the memos from the State Department about how to stamp the I-129S, and they will put dates there that don't correspond to the period that was requested on the petition. They will put dates that maybe correspond to the person's passport expiration or some other thing that will be confusing, or they'll put a 5-year period when they're supposed to put a 2-year period, or just all kinds of dates that could be on that form. Those should be corrected, and it's important for you to highlight to the worker when they're going to understand what type of a period should be on the I-129S, so that if they mention to the consular officer, look, I think you're supposed to put 3 years there or 2 years or whatever it is, that might be helpful because you won't have to correct it after the fact. These inconsistencies create errors when people are entering the U.S. They get an I-94 date that could be the wrong date, and that will again cascade into other problems down the road when they realize, hey, I'm expiring, or hey, I've been given a period it looks like it's too much and I'm confused, I don't know what it means. All kinds of things can happen, and these should be corrected, okay? So another development is as of, is today the 10th? That was yesterday. right? I'm kind of upside down on my dates. Today is the 11th. But yesterday, as of yesterday, when you're filing an extension inside the U.S. for somebody who holds a blanket petition that was originally obtained at the consulate, now when you file an extension, you need to submit the I-129S for any extension or change of status that you might be filing for that person. Kind of timely, right? Finally, here's some trends that I think are interesting. From the Ombudsman report from USCIS 2016, these are request for evidence rates at the two different service centers that will adjudicate L1 cases, all right? So for California Service Center on an L1A, it's shown that during 2015, the number of RFEs issued were risen to 55% of all cases filed, all right? And for Vermont Service Center, that number was reduced down to reduced to 29% from 44% the previous year. So a trend that shows an actual improvement, right, in the adjudication, and at least from Vermont Service Center, which as immigration attorneys, I think most of us find that practicing before the Vermont Service Center is a lot more enjoyable than practicing before the California Service Center. Because of these numbers, you can see it, right? They issue so many less RFEs at the Vermont Service Center. On the L1B side, the number of RFEs issued to through the California Service Center for L1Bs came down to 44%, which before was even higher, and at the Vermont Service Center is down to 33% of cases filed, probably as a result of the policy memorandum that we've been talking about, and also because I think as practitioners and others, when we receive the policy memorandum and instructions about how these should be filed, we start to understand better what USCIS is looking for, and giving better documented cases, things are coming out better, and we're seeing improvements all around. And hopefully, I think as President Obama wanted, that this should be a process that is not so complicated, that the companies need these workers and should be tolerated, not something to be put under a microscope in every case. And so these improvements are here. And I think rather than just starting with questions, why don't we start first with Anandita, if you have some comments or thoughts about the things that I've been mentioning, and then we'll go to Samir.
Thank you, Jake, for your presentation and the opportunity to share my thoughts about the subject. Essentially, our experience has been, there's been a dichotomy. I think I mentioned this in yesterday's presentation. For those who weren't there, I'm going to repeat myself. With the August 2015 memo, it's very clear that there was the intent to relax the interpretation, specifically of L1Bs. I'll just start with L1Bs real quick and then change to L1As. That being said, as Jake pointed out, the specialized knowledge is knowledge that's not easily obtained or imparted. In the final version, that's what they've come down to. It need not be proprietary or narrowly held. The specialized knowledge candidate need not command a high salary. And last but not least, the test of the US labor market is not required for the L1B visas. Now, that being said, the documentation, which I cannot stress enough, has to be almost perfect, if not perfect. In the L1B program, we've discussed this, wherein which it is difficult to document, for the most part of the IT companies, some that are in this room, some that might not be here, especially for smaller corporations, IT corporations, that you have what is considered to be proprietary tools. There are, the packages, the ERP packages like SAP, Oracle, and then there's the Java, XML, UML, J2E, all those packages. None of that is proprietary to the companies at large, other than, of course, Oracle can claim its products are proprietary. SAP can document that its products are proprietary. Other than that, how do you make a legitimate, non-fraudulent business case to document that, this is what our tool is? You literally have to come up with, not everybody is as large as, the top 5 or 10 Indian IT companies. Not everybody has their centers of excellence, but how do we still work with this parameters of the L1B program given the rules as they are. And that is where you will have to come up with a legal, legitimate framework where you will have to conduct or schedule and create a training schedule. You have to have experts at the project manager level who invest time to train the new joinees or whoever it is that they've allocated to serve this particular client, provided you can document the proprietary tools that this company has. To put it very bluntly, if you don't have that, don't try this visa. You'll just be wasting money and hurting the reputation of the company. With every denial, both at the blanket stage and also the USCIS, it is going to be noted against this company, and any future applications will affect you adversely. There's no denying that. Similarly, with the conversation that I was sharing with you guys yesterday, that the consulate, which is not bound by USCIS regulations, has a very different interpretation at the blanket petitions, where they are not very blatantly saying we're not required to follow the August 2015 memo. So their adjudications, which we know for all the the professionals in this room, we have experienced for most companies a very high percentage of L1B specifically denials. And they said that irrespective what the memo relaxes, we will interpret it on a case-by-case basis, company-by-company basis, where you can then, you still need to document to us, was this knowledge proprietary? Has this person gotten training? Has this person documented experience at the corporation, hypothetically here in India? And is that the reason why this experienced, trained professional is being transferred to the US? When we review documents, I will tell you, it's very difficult for us to, assess something that is weak and say, oh, this is doable. When I review a document, a petitioner can give us detailed pages and pages of what this tool is, but have nothing to document that it's proprietary. There are no white papers, there are no reviews in the market, there are no patents. Additionally, on a resume of the candidate, there's no mention of the proprietary tool. How does that even happen? If you claim that this is your best candidate trained for years on end on this one particular product based on which he or she's been selected for the L1B visa, and there's no mention in the resume, it's pretty transparent that most of the documentation that preceded the resume were just, created, for lack of politely putting it, So be very careful with the L1B. It is not an alternative when the H1B cap has been reached. This has been the biggest criticism of the Indian industry, I would say, specifically IT, otherwise all disciplines, where we use it interchangeably. I get, our practitioners at our firm gets, our professionals at our firms on a daily basis, and I'm sure at your executive levels you get it also from the sales managers, the project managers from bottom up. Oh, the HCAP has been reached. Can we just use the L1B? Why can't we use the L1B? So please, I appeal to each one of you at your various levels of seniority. You have a fiduciary responsibility not to misuse this visa, because at the end of the day, it's going to come back and haunt you. If, for one, you don't have your products. Now, there are many companies that we represent that have their suite and tools, and that are established. You can Google it. You can Gartner reports. Your marketing, advertising things. There are announcements in the Indian newspapers. All power to you. It's a matter of documentation of what is a fact. Quickly to touch base on the L1A. Be very careful when you document an L1A. Once again, if the person does not have an L1B, oh, why can't we try an L1A? An L1A is very clearly a managerial position. Who is a manager? We talked about it yesterday. There is a functional manager, which is honestly, in my opinion, a little more difficult to do. And then there is, for lack of better ways, a regular manager. What is a regular manager? How will you prove that a regular manager is a regular manager? I'm just not going to go by what you say. The documentation, at least the way we assess a case, begins with as basic as the organizational chart. There has to be a tiered approach. In my opinion, if you have an employee pool of 300,000 employees and you show me an org chart of one person as a program manager with 4 subordinates, I'm not going to approve it. So depending on the size of the company, you have to put your alerts on. So there, typically we also do not approve cases or process cases that just have in an IT environment, I hate to go back to an IT example, but systems analysts, program analysts, software application developers, there has to be another role of a sub-manager beneath you, and then some people underneath that professional. Or else, if you just have a one line underneath the so-called manager that you're showing me in the org chart, you will get what is called an RFE for what is considered to be a first-line supervisor. And that's going to be, at the RFE level, very difficult to overcome. So working our way backwards, you know what the USCIS is looking for, you document your petition accordingly, and again, non-fraudulently. The other thing is you have to prove that this candidate in India, in a hypothetical example, has performed as a manager for at least a minimum period of 1 year. Again, the requirements are exactly the same. I'm looking at org charts, I'm looking at detailed managerial job duties, which are not 2 pages and half a paragraph each. Which are not 2 paragraphs and half a page. I'm looking for something that's at least a couple of pages. I'm looking for something that breaks down with percentages of exactly how the managerial responsibilities have been conducted. And in addition to, I need subordinate job duties. It seems to be a lot of work, but guess what? That's at least what USI law does on almost a daily basis. Because the more you put into it, the less chances of an RFE, the less work afterwards. So similarly, you create the same typecast for the offered position in the US. I mean, I can only speak from experience. The law, Jake did a good job of outlining it. I can't emphasize enough. Please be careful with the L visa program. There is a lot of fraud, if you want to call a spade a spade. So be careful of how you implement this for your company. I think you all, like I said, have a responsibility to make sure you're compliant with the law. And in keeping to what the other panel wrapped up, in the new Trump era, compliance will be even more a formidable thing that the USCIS and ICE and everybody else will be looking into. And if you slip up, the cost of doing business is going to be more higher than it has been so far. Thank you. Samir, thank you.
Thank you, Jake. I think, Anandita and Jake has covered a lot of aspect, and in the audience, we all know a lot of things on the L1. What I would like to emphasize on a couple of aspects, right? The first aspect, more from a corporate standpoint, is a selection criteria for people that we are sending overseas, right, on a short and long-term assignments. Very, very importantly, I'm not sure whether companies are investing a lot of time in building up such a process where you can go and select a person who is really qualified from the group of people for applying for any kind of a visa, be it at a US or a non-US, right? So especially on the L1, we are seeing a trend that people are just getting selected randomly, right? So I think we as a professionals go back to our business leaders and educate them that you need to put some process in place within your group, that these are the group of people, but 4 or 5 people are really, really qualified. The definitions what we have for L1, right, in terms of the policy memorandum that has been published, why can't we take that and make such process when we go back to our business leaders, right? So I think that is one of the very important aspect. The other aspect, what I'm seeing, not from the US, but from the other countries, right? One of the important documentation that has been asked for any work visa is how this foreign national is going to train people in the US to get that position, right? I don't think so that's there right now for US, but other countries are already following that practice, and I would not be surprised to see in this year, Trump year, that may come to US as well, right? So give me the declaration that this foreign national is going to train 4 or 5 US national and then again go back to the home country, right? So those are the few aspects that what we are seeing right now, more from a L1 standpoint. And as Anandita and Jake has just kind of emphasized, the compliance is the highest priority, and we will we'll see in near future that more and more stricter controls are going to put in place, right? So I think those are the few aspects that what I can add more from a corporate standpoint. Thank you.
Awesome. Thanks, Samir. Anandita, why don't we jump into some questions and talk about what the audience is interested in hearing right now, I think this is a great moment. We can do that. So looks like one of the top questions is, first, hang on. I think it's this one here. Here we go. With the new I-129 form, how should it be shown that additional compensation is there for maybe some dorms or fixed allowances, or maybe reimbursement for costs like housing? And I might just fathom a quick answer to this, that there's a box under the salary number that the employee will be given that's called other compensation, and that's where you will fill in details about additional benefits that could be there. Could be standard health benefits or other kinds of things like that. Should be mentioned, but certainly if there are housing allowances or other maybe transportation and relocation benefits, those would be mentioned. And also variable pay or bonuses, I think, are critical, especially for the L1A workers, the executives. They should be having compensation bonuses for performance, or if there are milestones being met. And I think that that is a very helpful thing to explain for USCIS to understand that the person is an employee of great importance. Any thoughts or want to add to that?
I think we traditionally, like Jake, you said, we put standard benefits and then describe the benefits in the support letter, in the section that deals with the position offered, and even a section to the beneficiary. So I think that's one way to still continue maintaining the way we complete the forms and still explain what standard benefits mean.
Okay. What are some ways to prove petitioner supervision for client placement of L1 visa holders? Samir, what do you think?
Yeah, so I think what we have seen in past in terms of where we are doing an on-site placement at the client side, firstly, L1 visa really gets tough in that area, right? We need to provide more documentations and to prove that this person is not going to work on the client